Okay, I think we might make a start. So, good morning, ladies and gentlemen. Welcome to Lodder's Property Dispute Team's annual Landlord and Tenant seminar. That's commercial landlord and tenant. Really great to see you on this very windy morning. I'm very pleased to introduce you to my co-presenters this morning, Vicky Khandker and Ellie Crofts. And as usual, we are going to take it in turns to take you through updates in law relating to commercial landlord and tenant, and also to tell you about some cases that have been reported over the last 12 months. And we hope that you find that information interesting and maybe even of some practical use for the months ahead. We will speak for about 50 minutes, maybe a little bit more, and then there will be plenty of time for questions at the end. Let you know that there's obviously myself, Vicky and Ellie, and we also have 3 other specialist property dispute solicitors. So the 6 of us do nothing else but deal with issues relating to property and land, and that covers a multitude of sins, but certainly including commercial landlord and tenant. So Vicky, you're going to start us off, so over to you.
Thanks, Jane. A new law is now in place, which I'm sure everybody has heard an awful lot about, to help resolve certain remaining commercial rent debts accrued because of the pandemic. The Commercial Rent Coronavirus Act 2022 received royal assent on the 24th of March. This means that from that date, a legally binding arbitration process is available for eligible commercial landlords and tenants who've not already reached an agreement as to outstanding rent arrears relating to the pandemic. I'm not going to talk about it in too much detail. 2 of our team, Katie and Lauren, gave a seminar on this in the middle of March, which is available on our website, but it is appropriate just to touch on a couple of points. The original bill was introduced under the framework of the Code of Practice for Commercial Property Relationships following the COVID-19 pandemic, and it's the version dated November 2021, because there were a couple of earlier iterations of it. The key principles of the code are fairness, affordability, and viability. The code applies to all commercial leases held by businesses which have built up rent arrears due to the pandemic, and it also suggests that agricultural businesses may want to apply the principles. However, it is only mandatory where the Act is applicable. The code states that the tenant's business viability should not come at the expense of the landlord's solvency. Tenants should never have to take on more rent or restructure their business in order to pay their rents. Those perhaps slightly contradictory. However, the code does stress that the aim is for the parties to share the burden. The Act introduces an arbitration scheme, which is binding and mandatory where it applies, providing one party makes a reference. If neither party makes a reference, then neither party can take action regarding any protected rent under the Act until the moratorium expires, which is currently the 24th of September 2022. The law applies to commercial rent debts of businesses, including pubs, gyms, and restaurants, which were mandated to close in full or in part from March 2020 until the date restrictions ended for their sector. And in England, that's the latest date will be the 18th of July 2021. Debts accrued at other times or by tenants who were not forced to close will not be caught by the Act. The government says that this will resolve disputes about certain pandemic-related rent debt and help the market return to normal as quickly as possible. And note that rent includes not only rent in its pure sense, but also service charge, interest, and VAT. The protected period under the Act is the period beginning on the 21st of March 2020 and ending on the earlier of the date the tenant was able to reopen in line with relaxation of lockdown restrictions. For example, that was the 12th of April 2021 in England for non-essential retail. Or alternatively, the date all government restrictions were lifted, being the 18th of July 2021 in England and the 7th of August 2021 in Wales. Note that claims issued prior to the 10th of November 2021 remain unaffected by the Act, but they are still subject to the Coronavirus Act 2020. Any claims issued after that date will be stayed for a determination under the arbitration process, albeit if they're not caught by the Act now, any existing stays should be lifted. So if you do end up in arbitration, it's just worth looking at what the arbitrators' considerations are, and they're set out in Annex B of the Code of Practice, evidence to consider when negotiating. And what that says is that when considering tenant viability and affordability, the parties and the arbitrator may wish to take the following non-exhaustive list of factors into account. And I've put those up on the slide, and we will be able to send the slides out afterwards if people would like them. These include the existing and anticipated credit debit balance, business performance since March 2020, the tenant's assets, bearing in mind that some of those assets may not be able to be sold without actually ending the business, the position of the tenant with other tenancies, such as the ability to absorb the costs within those other tenancies, government assistance received by the tenant, including loans and grants, dividend and bonus payments to shareholders, excessive or unreasonable dividend payments to directors, overdue invoices or tax demands, unpaid or returned checks or electronic payments, exceeding overdraft limits, creditor demands, money judgment, expert evidence perhaps from an accountant as to the tenant's current trading position, shortfalls in share issues, evidence of prior refusal of further credit, funding or lending, failure to meet budget projections, loss of important contracts, insolvency of a major customer, unexpected retentions, or loss of key personnel or staff redundancies. And importantly, these factors may also be used to assess the impact on the landlord's solvency if the landlord wishes to provide evidence of the same. It is a non-exhaustive list, but it's been designed to provide an indication of possible relevant information which should be applied flexibly on a case-by-case basis. And the approved arbitration bodies are now listed on the government website, and they include the obvious candidates such as the Chartered Institute of Arbitrators and the RICS. Parties are being encouraged only to use the arbitration process as a last resort. That may be that if there's still considerable arrears at this stage in the timeline, maybe that we kind of are at the last resort situation if parties haven't been able to agree proposals. Query whether landlords will elect to use it to try and seek a determination once and for all. Tenants, I suspect, may be more likely to use it, although there are, of course, situations we see where tenants are perhaps chancing their arm a little bit, and so may not be quite so keen to dive into arbitration. Note also what happens after the 6 month period. Firstly, could that period be extended? And we just don't know at this stage. I suppose it will depend what the take-up is and how quickly arbitrators are able to get through these decisions. But also, if neither party elects to use the arbitration process during that period, then when it does end, effectively all bets are off, and it would seem that landlords will then be able to pursue the protected rent debts in the normal way. So moving on to what this means in respect of non-protected rent debt, so any rent that isn't covered by the Act. From what I'm hearing in the markets, landlords are now focusing on the non-protected rent debt and just waiting to see what happens with the protected rent debt. Now that the restrictions have been lifted, there's still quite a lot of tenants still not paying the rent 9 months on from the end of the pandemic enclosure terms. So we're back to the pre-pandemic options. The previous COVID-related restrictions on pursuing non-protected rent debt under Section 82 of the Coronavirus Act have been lifted in England, but no, they won't be in Wales until the 24th of September. What this means is that landlords can now pursue remedies subject only to the restrictions in place prior to the pandemic. However, just remember that any action can only be in respect of the non-protected arrears. So these include things such as the commercial rent arrears recovery, or CRAR. We're back to the regular arrears threshold, which is a sum equivalent to 7 days rent. Forfeiture, landlords can now forfeit for non-protected rent debts, but just bear in mind that prior to the coming into the force of the Act, a landlord could temporarily not waive its right to forfeit by chasing arrears, but it now can. If you accept rent, you can waive your rights. Note also that if a tenant seeks relief from forfeiture, it only has to pay the rent for which the landlord has forfeited. So if you accept any payment of rent now, you can waive the right to forfeit in respect of all historic arrears, and use of CRA will also waive the right to forfeit. Parties are back in the position of being able to use statutory demands and following those up with winding up. And note also that reliance on ground B under the Landlord and Tenant Act 1954, which is persistent delay in paying rent, will now be open to landlords to oppose the grant of new tenancies on that basis. But it will only apply to the periods post the 24th of March. An important note should also just be made with regard to apportionment of rent. If we can have the next slide, please. If rent is paid during the moratorium, it must be allocated to the unprotected rent debts first. So if tenant starts paying rent, you can't set that off against the against the protected rent debts and then seek to pursue the unprotected rent debts. It's got to be allocated to the unprotected rent debts first and not discharged against the protected debts. So I just want to look at a very, very brief case study. So we have an example of a cinema. The cinema hasn't paid any rent since the December 2019 quarter. The rent debt for the period up to the 18th of July 2021 is protected. The debt post the 18th of July is not protected. And remember that post the 24th of March, you can waive the right to forfeit. So the landlord chases the arrears on the 23rd of March 2022 and reminds the tenant of its liability for the March 2022 quarter. The tenant pays a quarter's rent on the 28th of March, making it clear that it is for the March quarter's rent. What can the landlord do in respect of the unprotected rent? And we've just got a poll to put up here. The majority of people, I think, are largely correct. Anyone that said court proceedings, CRA or statutory demand are all potentially correct. You can't arbitrate in respect of the non-protected rent debts. That would only be in respect of the protected rent debts. With regard to forfeiture, there would be a real concern here that the landlord has waived the right to forfeit by the payment of the March quarter rent on the 28th of March. The one thing I would be slightly wary of is that if it's a cinema, can you query whether there is anything against which you could really exercise CRA? I mean, I don't know, there may be, but I would just exercise caution with that because it might be quite difficult to actually go in and try and take any possession of any goods. So I think really I would be focusing on looking at suing for the arrears or statutory demand. But importantly, because of the risk of waiver of forfeiture, what I would be suggesting is that you need to take advice as soon as possible to try and avoid limiting your remedies in any way. I'm now going to move on to look at some of the cases that have been heard through the courts with regard to COVID arrears. These cases might arguably be superseded by the new legislation, at least in part, but the principles may still be applicable for landlords now seeking to sue for non-protected arrears. So the first case I want to look at is the London Trocadero case. Here the tenant was a cinema and the landlord sued for unpaid rent of around 2.9 million and sought summary judgment. And the tenant defended it on the following basis. Firstly, that terms should be implied into the leases to the effect that payment of rent and service charges should be suspended during any period for which the use of the premises as a cinema was illegal and or during which the attendance would not be at a level commensurate with that which the parties would have anticipated at the time the leases were entered into. Secondly, that there had been a partial failure of consideration on the basis that the payments under the leases were for the use of premises as a cinema, with the result that no payments were due under the leases for any period when the premises couldn't be used as a cinema. And finally, in this particular case, that the tenant was entitled to set off in equity its counterclaim in respect of insurance issues against any other sums otherwise found to be due. Now, the court found that they couldn't imply terms into the leases. The proposed implied terms failed the business efficacy test and the obviousness test and were inconsistent with the terms of the leases. It was suggested that the landlord would be able to insure against any loss of rent, but it was equally open to the tenant to do so. It was therefore a matter of negotiation between the parties as to where the risk should lie. The fact that in this case the risk was with the tenant didn't lead to the conclusion automatically that the leases lacked commercial or practical coherence. Further, the landlord had expressly given no warranty that the premises could lawfully be used as a cinema. There was also a rent suspension clause, and as express provision had been made for rent suspension in certain circumstances, that meant it wasn't obvious that a further term should be implied, providing for a suspension of rent or service charge in other circumstances. The second argument in respect of failure of consideration, failure of basis, essentially failed for the same reasons. The key question here was the continued and uninterrupted lawful use of the premises as a cinema fundamental to the basis on which the tenant entered into the leases, or was it simply an expectation which motivated them to enter into the leases? And the court found that it was the latter. And again, the court considered that there may be other circumstances where they could not operate, such as damage to or destruction of the premises, which had been dealt with in the lease. There was also the express failure to warrant that the premises could be used as a cinema, and this ground also failed. Finally, with regard to the set-off, the court did find that this ground succeeded up to the maximum level of the potential counterclaim by the tenant of £621,000, and this was therefore set to be determined. So here, summary judgment was given for the landlord, subject to a reduction of the £621,000 to be determined later. The tenant has obtained permission to appeal to the Court of Appeal, which has now been listed for the 21st of June this year. Another case which looks at similar principles is the Bank of New York Mellon case. And here the tenants included Cine UK, Mecca Bingo and Sports Direct, amongst others. They'd all been unable to trade to various degrees during the lockdown periods. But it had also here transpired that the landlords had been able to procure pandemic insurance, which included loss of rent, irrespective of damage to their buildings. So the landlord sued for unpaid rent, and the tenants defended the claim on a number of grounds against which the landlord sought summary judgment. They argued that summary judgment was an unsuitable procedure for claims involving technical defences of some complexity, particularly given that the court might be assisted by an appreciation of the commercial background to the leases before it. They said that the landlord should have been negotiating with their tenants rather than proceeding against them in accordance with the code of practice. Here, they said the operative words in the rent cessor clauses in the leases, damage or destruction, should be interpreted as including an ability to trade, and terms to that effect should be implied. Given that the landlords had actually insured against loss of rent in this exact event, and the tenants paid for that insurance, they should be entitled not to pay the relevant rent. And they finally argued that lockdown was a frustrating event and the leases should be treated as suspended or terminated. The key factors for the judge appeared to be that, firstly, the pandemic and lockdown was not unforeseeable, given there was an earlier SARS outbreak some years before. Secondly, that it was not therefore surprising that the landlords had insured against such matters, and that it had been open to tenants to similarly take out business interruption insurance. And these observations disposed of any arguments based on interpretation or the need for an implied term. With regard to the arguments concerning the insurance, although the landlord's policy did include insurance against loss of rent in the current circumstances, whether or not there was physical damage to the premises, the insurance was only activated if the rent cessor clauses were in operation. As the rent cessor clauses themselves required damage or destruction to the premises, and there hadn't been any such damage, the insurance didn't come into force. The master noted that there was no respectable support for the proposition that a lease could be suspended temporarily under the doctrine of frustration. And he did not see that the reasonably expected period of closures would ever have been greater than 18 months, as each of the leases had at least a year left to run from that point. With 1954 Act protection, that wasn't sufficient to frustrate the leases. Now, in this case, an appeal has also been listed for the 21st of June this year, and presumably will be heard together with the London Trocadero case. Similar principles were also argued in the Atmore Centres and TFS, Commerce Real and TFS. So these all concern the perfume shop. And again, I'm conscious slightly of time, so I'm not particularly going to run through those because they are very similar clauses to the other cases that I've talked about. But in particular, they included arguments about the rent suspension clauses, and the tenants tried to argue that they extended to non-physical damage brought about by the pandemic, but that failed. And the court stressed that the code of practice was just a code of practice. The government had specifically imposed restrictions on landlords at that time against using rights to forfeit and CRA, but they clearly hadn't restricted the ability of a landlord to bring a debt action. And instituting proceedings at that time could not be described as taking advantage of a loophole in the legislation. They also found that there were no grounds for improving the tenant's position by implying terms into the leases. So whilst some of these cases await appeal, I would be surprised if a different outcome is reached. On that basis, it does seem the door appears closed to tenants who have unprotected rent debts to argue that they should have some form of relief. The government, whilst encouraging parties to negotiate, has specifically chosen to legislate only in respect of those businesses which were forced to close in some form or for a specific period of time. And so I'd be surprised if the courts determined that the tenants could rely on these types of arguments unless there is something technical in relation to the specific wording of the rent cessor clauses that gets them around that. That's all from me. I'm going to hand over to Ellie now to look at some cases on the 1954 Act.
Thank you very much, Vicky. Good morning, everyone. As Vicky just said, I will be running through some recent case law on the Landlord and Tenant Act 1954, also looking at things like turnover rents and pandemic clauses. Firstly, however, I'm going to look at an update on a major case from last year, which I believe Jane covered in our update, Capital Park Leeds and Global Radio Services. This case considered the definition of vacant possession in the context of the conditionality of break clauses. The tenant here had exercised its right to terminate its lease in November 2017. The notice was validly served, but the issue in this case relates to the break conditions, one of which was that the tenant give vacant possession of the premises to the landlord on the relevant tenant's break date. The landlord alleged that the tenant had not given back vacant possession of the premises because of a programme of works carried out by the tenant prior to the break date. The tenant had removed a large number of items from the premises, including landlord's fixtures, such as radiators, floor finishes, ceiling tiles and lighting equipment, or that were part of the building's original base build. The landlord claimed that landlord's fixtures, and indeed the building itself, were part of the premises, and therefore the tenant had been unable to deliver vacant possession of them. The High Court had been persuaded by this argument and made the rather odd decision that a tenant could remove too much at the end of a lease to give vacant possession. Understandably, the tenant appealed, and the Court of Appeal has reversed the High Court's ruling. The Court of Appeal held that the term vacant possession is not concerned with the physical condition of the premises, but with possession of them by what they call the trilogy of people, chattels and interests. In this regard, the court referred to the earlier case of Goldman Sachs International and Procession House Trustee, which stated that vacant possession requires a tenant to return the premises to the landlord free of or vacant of, firstly, people, secondly, chattels, which cause a physical impediment, which substantially prevents or interferes with the enjoyment of the right of possession of a substantial part of the property, and thirdly, legal interests. The overturning of this ruling has now reinstated the conventional wisdom as to the meaning of vacant possession, i.e. that whilst you can fail to deliver vacant possession by leaving too much in a property, you can't fail to do so by leaving too little. So there isn't really any new law here, but there are a few helpful reminders that have come out of this case. Firstly, people can include employees and contractors in the usual way, but also can include unlawful occupiers, such as trespassers or squatters. So tenants should consider securing the premises until the break date, particularly if they do vacate before the break date. With regard to chattels, generally a form of de minimis rule applies. Tenants should ensure that larger items and machinery, equipment that they use is removed. But if any items do remain, the question to ask is whether they substantially prevent or interfere with the landlord's enjoyment or possession of the premises. Therefore, the odd file or kettle shouldn't generally prove fatal to a tenant in successfully operating their break option. In respect of legal interests, before serving the break notice, tenants should carefully consider whether there are any interests which might give a third party a right to possession of the property, such as subtenancies or licenses, and decide how to deal with terminating those interests before the break date, and preferably before serving the break notice itself. So turning now to issues under the 1954 Act, and we'll look firstly at pandemic clauses. I think much as we would like to think the worst of the pandemic is now behind us, pandemic clauses are still quite common in lease renewals. The starting position for the terms of a new lease under Section 35 of the 1954 Act is that the new lease should be substantially on the same terms as the old lease. If one party seeks to depart from this starting point, then it must satisfy the court that it's reasonable to make the change. And this has been the case since 1983 and the case of O'May and City of London. Most old leases are obviously not going to contain pandemic clauses because there wasn't a pandemic. And pandemic clauses are generally those which permit the rent to be suspended in the event of a pandemic forced lockdown. So the question is whether tenants are able to push these clauses into lease renewals where it's obviously a clear departure from the old lease. There's a couple of cases to discuss on this point. The first one is Poundland Limited and Top Lane Limited. And here the parties had already reached agreement on the annual rent and the term and agreed no break clause. But Poundland sought a number of changes to the terms of the lease, including the following. They sought payment for the rent to be in arrears instead of advance. The court dismissed that. A proposal to vary the forfeiture clause by including a proviso that the landlord couldn't forfeit during a lockdown period. That was also rejected by the court. The third amendment they sought was to adjust the rent suspension clause. Poundland proposed that the annual rent should be reduced by 50% during a period in which a use prevention measure applied. This would be consistent with many rent suspension clauses now being agreed, whereby closures brought about by lockdown measures result in rent being wholly or partially suspended. The district judge in this case was of the view that the effects of the pandemic and the possibility of the government imposing further lockdown restrictions were indeed part of the relevant circumstances to be taken into account under Section 35 of the Act when determining the new lease terms. But the judge also felt that the imposition of such a clause, which would reduce the tenant's liability in circumstances where it was difficult for the tenant to trade, was not a fair and reasonable amendment to make. He felt that the tenant was seeking to impose a new risk upon the landlord, sharing what was otherwise the tenant's risk of having to pay rent during difficult trading conditions. This case differs from the decision of the Winchester County Court a couple of weeks earlier in W.H. Smith Retail Holdings Limited and a German name that I'm not going to attempt to pronounce. Here, both parties had accepted that the tenant's renewal lease should contain a pandemic rent suspension clause to suspend the 50% of the rent, but not the service charge, in the event of further disruption caused by the pandemic. The tenant was also to account for any government assistance that it might receive in respect of the rent. The issue that remained unresolved was that what should trigger the operation of the rent suspension clause. The tenant proposed it should be triggered if a non-essential retailer could not open the premises due to a pandemic, an epidemic, a public health emergency or outbreak of communicable disease, or an act of parliament or statutory power exercised by the government in relation to COVID-19 or any subsequent strain of the virus. The landlord proposed that the rent suspension should operate if the tenant was required to cease trading from the premises as a result of UK government measures in response to any pandemic. The landlord argued that the nature of the tenant's business gave it a competitive advantage, as the business had been able to remain open through most of the UK lockdown restrictions. From the premises, the tenant operated a post office and as such had remained open throughout the pandemic. However, the property was in a shopping centre and footfall in the shopping centre had reduced dramatically and the tenant's sales had fallen by 90% during the lockdowns. The impact of the restrictions was to deprive the tenant of virtually the whole benefit of its occupation of the premises. The judge agreed with the tenant. Any benefit to the tenant of being able to remain open in an otherwise deserted shopping centre was more notional than real, and the court ordered that the pandemic rent suspension clause should be triggered by the closure of non-essential retailers. The court accepted that since both the landlord and the tenant were proposing to include the pandemic rent suspension clause in the new lease, the tenant didn't have to bear the burden of persuading the court to impose the clause. And the judge noted that even if that position was wrong, he would find that essential fairness demanded the clause in any event. And also, as a further blow to the landlord, he noted that the inclusion of the clause should not result in an uplift to the rent under the new lease. Now, these cases were both county court cases, and so they're not binding, but they do provide some insight into current judicial thinking on the application of the OMA principles under Section 35, examples of the arguments that can be advanced on behalf of tenants and how landlords might counter those arguments, and also an indication of the extent to which county court judges may be persuaded. Also on the topic of the 1954 Act, the December 2021 case of Savile Eagles and Jane concerned an interim rent assessment and the impact of the pandemic. Ordinarily, the rent payable by the tenant during the period between the old lease ending and the new lease completing will be the rent determined or agreed for the new lease, and it's then backdated at the end of the old lease or the expiry of the relevant notice. However, under Section 34D of the Act, the court does have a discretion to depart from this position, where either the rent for the new tenancy differs substantially from the rent which would have been ordered under Section 34, if the interim rent were assessed at the date it became payable, or the terms of the new tenancy differ from the terms of the old tenancy to such an extent that there is a substantial difference in rental values. In the Savile Eagles case, the rent levels had changed substantially during the tenant's long period of holding over throughout 2019 and 2020 due to the pandemic, and therefore the court was prepared to significantly reduce the interim rent payable to take account of the good year of trading in 2019 and the exceptionally poor year of trading in 2020. Also on lease renewal rents, the October 2021 case of W number 3 GP and JD Sports concerned the lease renewal of retail premises in Derby. The landlord here served a Section 25 notice which terminated the lease in June 2017. Under the existing lease, the tenant had paid a turnover rent equivalent to 8% of the gross sales, and that had historically yielded a rent of about £500,000 per annum for the landlord. So understandably, the landlord wanted to include a similar clause in the new lease, whereas the tenant wanted a fixed rent. There was a 4-day trial, during which the court considered more than 40 comparable properties, and after this, the court declined to award a turnover rent. The reasoning was, given the rise in online shopping, the effects of the pandemic, the size and configuration of the premises, the judge decided that there would be limited interest in these particular premises, and any hypothetical tenant would have an extremely strong negotiating position. The judge also considered that the rental value was too high for the market, and a turnover rent would not result in a true market rent, as is required by Section 34 of the Act. Now again, this is a county court decision and not binding, but it is interesting to note that the court seems unlikely to award turnover rents where one party disagrees. However, it's worth considering in the current economic climate, a turnover rent may well be attractive to a tenant seeking to protect itself against loss of income arising from future government restrictions, and it might be something that more tenants would consider in the future. Finally, under this rather broad heading of 1954 Act cases, I want to discuss the case of Macy and Pizza Express. And this considered the relevant intention a landlord's required to show when objecting to the grant of a new lease under grounds F and G. In this case, Pizza Express opened a restaurant from premises in Exeter. The landlord served a Section 25 notice stating it would oppose the grant of a new lease on ground G, which is that the landlord intends to operate its own business from the premises. The landlord's stated intention was to use the premises as a bistro. The first instance, the county court considered the landlord's evidence and found it insufficient evidence of that intention. The judge indeed said some of the assertions of the landlord and related documentation raise an index of suspicion. Came to this conclusion because the landlord gave evidence in his witness statement that he had engaged accountants to prepare a business plan which would include projected profits for his bistro. He failed to disclose that business plan until very shortly before trial, and even then it still didn't contain the projected profits. He also alleged he'd carried out food hygiene and licensing training, but was unable to provide evidence to back up his assertions. The court also found that the landlord hadn't incurred any significant costs in preparing to take over the property and run his own business. As had been previously noted in the Francis and Cavendish Hotel case in 2018, incurring costs demonstrates a commitment to move beyond contemplation and into the valley of decision. The court considered this to be a significant point and was one of the reasons for dismissing the landlord's case. The landlord appealed to the High Court, but unfortunately for the landlord, the High Court agreed with the County Court. It considered the landlord lacked the subjective intention necessary to satisfy ground G. In the High Court appeal, the court emphasised that a landlord must show three forms of intention: subjective, objective, and unconditional. And these were explained as follows. The subjective intention is the landlord's firm and settled intention to bring about a certain state of affairs, in this case to operate a bistro from the premises. This must be supported by evidence. The objective intention is that on an objective basis, the outcome is achievable, or as the judge said, rooted in reality. Although the court doesn't police the commercial viability of the landlord's stated intentions, the more unlikely the business venture, the more the evidence of the subjective element is going to be undermined. The requirement for an unconditional intention was explained by the Supreme Court in Francis and Cavendish. The landlord's intention must exist independently of the tenant's statutory claim for the new tenancy, so that if the tenant remained, it would indeed obstruct the landlord's plans. If a landlord claimed it had a firm and settled intention to occupy a building for business purposes, but the tenant then vacated voluntarily, meaning the landlord would not then go ahead with his plans, the intention would only be conditional and would not therefore satisfy Section 31 of the Act. The takeaway for landlords from this case is to ensure witness evidence is corroborated with independent documentation, and the reminder that more than mere contemplation will be required in order to satisfy the courts on grounds F and G. Finally, in this section, before I hand over to Jay, I'll be looking at a recent case on keep open covenants. This is a clause that obliges a tenant to keep the demised premises open for trading throughout the terms of the lease, and are most commonly found in the retail sector. The case of Sapphire 16 SARL and Marks and Spencer's is a Scottish case, which highlights the different way in which this issue is treated both north and south of the border. So here, M&S held a lease in a shopping centre in East Kilbride in Glasgow. The lease required the tenant to keep the premises open for business during normal business hours. When COVID-19 restrictions were introduced in March 2020, M&S kept the store open for the sale of food, but otherwise it closed everything down. When restrictions were eased, they didn't fully reopen the store. The sale of food was greatly depleted, mostly just a few sandwiches and some juice. There was no stock in the clothing area, and there was also a sign on the door which directed shoppers to another M&S store. The landlord wasn't having any of this and obtained an interim order requiring the tenant to keep the shop open and sufficiently staffed, stocked and furnished. M&S then decided to keep the shop as an outlet store which sold clothing clearance items and no food. The Scottish Court of Session then had to determine whether M&S had breached the keep open order, and if so, whether it was in contempt of court. The court held that M&S had breached the order as it was trading only half-heartedly, but that on balance there had been no deliberate defiance of the court order by the tenant and therefore no contempt. Now, as I say, this is a Scottish case, and in England and Wales, the courts are generally not prepared to force tenants to stay open for business. However, the court will award damages against a tenant who ceases to carry on a trade in breach of covenant or otherwise breaches the trading covenant. One of the reasons for not granting mandatory injunctions in this jurisdiction is the difficulty for the court in determining exactly what has to be done in order to comply with the covenant, and also the risk that the court gets involved on repeated occasions, effectively micromanaging performance of lease covenants. And this certainly appears to be a feeling echoed by the judge in the M&S case, who said he was hopeful that sufficient steps will be taken by M&S, or we'll inevitably find ourselves back in court in another month. So that's my round of the 1954 Act case law, and I will now hand over to Jane, who's going to be talking about applications for consent and subletting.
Thank you very much indeed, Ellie. Yes, so I am going to start off looking at a case relating to applications for license to, it's an application for license to assign, and the case was between Rolo Gab and Megdad Barakazad, and it was heard in the High Court last year. You can see pictures of Mr. Gab and Mr. Barakazad. And these gentlemen, both billionaires, and both had been in court last year because Mr. Farrakazad, the landlord, had tried to forfeit the lease to Mr. Gabb, which was a long leasehold of 120 Kensington Park Road, because Mr. Gabb had put curtains up at his windows rather than blinds, or actually I think it was the other way around. Mr. Farrakazad took him to court and was unsuccessful, but that was all over the tabloids at the time. So Mr. Farrakazad obviously wanted to win something, and so he, when Mr. Gabb sought to sell his lease, and I should say that although this is a long leasehold case, the principles apply equally to commercial leases as well. So Mr. Gabb was trying to sell his lease for more than £3 million, and the landlord was basically being very difficult on purpose and delaying and not providing consent. And so Mr. Gabb lost his first proposed sale, and by the time it got to trial, he had a second sale pending, but it was at a lower sale price. So what Mr. Gabb was saying is that in breach of the Landlord and Tenant Act 1988, Mr. Farrakazad had unreasonably delayed and withheld consent. How did Mr. Farrakazad justify his conduct? Well, firstly, and if we could have the next slide, please, he said that the application for consent had not been validly served because the request had been by email. And the Landlord and Tenant Act 1988, Section 5, requires service by reference to Section 23 of the Landlord and Tenant Act 1927. And these require, or these state that service must be basically by hand or by recorded delivery, and there's no provision in those acts for email service. And so the question before, one of the questions before the court was email service sufficient? So I'm going to just run a poll here. Do you think, bearing in mind what I've just said, that email service was acceptable? Yes or no? And I know a lot of people obviously these days do use emails, and I think particularly when requesting consent to sign and sublet, I think it is quite a common way. So we'll see what sort of result we're getting here. Angela, can we?
So 71% of people say no and 29% of people say yes.
Thank you. Okay, well I can see why that result has come through. The court said that actually email service was satisfactory, and that was because the court said that the provisions in the 1988 Act, referring to the 27 Act, were permissive rather than prescriptive, and so the court said that so long as the concept of service had been satisfied, such that a request had been delivered to the landlord, that was sufficient, which I was quite surprised about, because I think we're all very aware of cases regarding service of notices, but the distinction is that the cases where people have been found to have to strictly comply with service provisions are where there is a contractual provision in the lease setting out what constitutes valid service. And so where there is a contractual requirement as to how service must be effected, then the court will interpret that very strictly. So the sort of much quoted phrase is if the lease says that the notice must be served on pink paper, serving it on blue paper won't do, or the other way around, I can't remember. But in this case, Gab and Farakazad, there was no contractual provision in the lease, and so the parties were just looking at the statutory provisions. And as I say, the court said those were permissive, not exhaustive. What else did Mr. Farakazad say? Well, he also said that, and if we could have the next slide, the way that the tenant had put it, or probably the tenant's agent, which when he asked for consent, he didn't say, please can I have consent? He said, please can I have the landlord's requirements in relation to license to assign? And the landlord said that wasn't clear enough and it wasn't a valid request. The court said, well, this is a matter of what would the landlord have understood by that, what was being asked for, and the court found that that was a valid request. So Mr. Farakazad was unsuccessful once again, but it just shows, I suppose, if you are a billionaire, you can afford to play these games, perhaps. So I'm sure Mr. Gab is very keen to leave the premises. So our next case is again on alienation, and is the case of Khandker versus Khandker Centrepoint, and here's a picture of Centrepoint, versus CID Investments. And here the tenant sublet without consent, and then the subtenant sublet without consent. And so what the landlord was left with was all these people in the property and no direct covenants between the subtenants and the landlord as provided for by the lease. And also the subrents were not at a level equivalent to the rent under the head lease and the service charge as the head lease required. So understandably, the landlord wasn't too happy. So there was no real doubt and no question that the tenant was in breach, but the question before the court was, on what basis should the damages due to the landlord be assessed? And should it be based on the profit that the tenant made as a result of all these breaches of covenant? Or should it be based on the sum that the tenant would have paid the landlord if there'd been a negotiation between landlord and tenant as to how much the tenant would pay to be released from these covenants? And the court basically said, much as it probably would have liked to punish the tenant for this blatant breach, it said no, because the landlord could never have actually made that money and that profit itself, it wasn't appropriate to award profit-based damages. And further, it said it would have awarded damages to the landlord based on a negotiated sum. But unfortunately for the landlord, there was no evidence before the court as to what that negotiated sum might have been. You would normally expect some sort of expert report to give the court an indication, and there was no evidence before the court. So the court made no award for damages at all. So I suspect the landlord had something to say to its legal advisors on that front. So the next case we're looking at, completely different, is about proprietary estoppel in the context of landlord and tenant. And this is the Earl of Plymouth and Rees case. Now, you might remember a couple of years ago in our annual landlord and tenant update, I discussed a case between these parties. It's a recurring theme today, warring parties. And it was about the Earl of Plymouth, who was the landlord of a whole swathe of agricultural land. And again, the principles here apply to commercial leases. But the Earl of Plymouth wanted access to the land that was farmed by his tenant, Mr. Rees, to do some investigative work. in anticipation of development, and Mr. Rees wouldn't let him on, and so there was a court case about that. Well, things have moved on, and the Earl of Plymouth now has planning permission for development, and so had served a notice to quit on Mr. Rees, who is 87 and very determined, and he's had a lot of press coverage. This is just one example of a picture in the press where Mr. Rees had put a load of these sad looking bales along the roadside to attract attention to his cause. So yeah, landlord has served notice to quit, and the tenant, Mr. Rees, claimed that he had been promised by the landlord that if he didn't oppose the landlord's planning permissions, then he would either be granted a tenancy of other land or he would get compensation. So this is the principle of proprietary estoppel. If you can show that you've been made a promise, you've relied on that promise to your detriment, then you can look to enforce that promise on the basis that it would be unjust for the other party to sort of take the benefit and not honour their side of the bargain. Here, however, the tenant, first of all, was unable to really be clear enough about the terms of the promise. The court says the terms of the promise were too vague. Also, the court found that Mr. Rees had not acted to his detriment because his farming business had been super successful and there was no real loss at all, on the contrary. And thirdly, Mr. Rees had actually opposed some of the landlord's planning applications, and so he failed fairly hands down. But although I can completely see why this is the case here, many proprietary estoppel cases, and we do quite a few of these, particularly in agricultural contexts, the terms of the promise often are pretty vague, and also proving reliance to detriment is also quite difficult to show, and again can be quite general. So many cases without very much evidence other than that the person who's had the promise made to them probably just orally, just really based on their evidence that they are regularly successful. So that's about proprietary estoppel. And final case for today is Marlborough Knightsbridge management case against Vivaz. This is not, so far as I'm aware, fully reported as yet. This is the Marlborough building, and the question was as regards fixtures here, because Mr. Vivaz owned 2 flats and he had removed and replaced the front doors on his flats. Again, this applies to commercial premises. And the landlord contended that removing the doors was removal of the landlord's fixtures and therefore a breach of the covenant. So the question here is, were the doors fixtures? So another poll for you. Do you think that the court found that the doors were fixtures or not? Well, in this case, I'm afraid the majority are wrong. The court did not find they were fixtures, although the first tier tribunal would have agreed with you, but the upper tribunal and the Court of Appeal said no, the doors are not a fixture, but actually part and parcel of the property itself, so an integral part of the property. And this highlights the importance of defining parts of the premises within the lease, and when you're considering these questions, checking for definitions in a lease. But here, in the same way as bricks forming part of the wall of a building go, and the court found that doors are the same. Without the door, you wouldn't have a complete sort of apartment. and so they were not fixtures. So just a quick reminder, you can have obviously tenants fixtures, which are fixed, which are sort of items that are brought onto the premises by the tenant and are fixed for the benefit of the tenant's trade or business. And tenants fixtures can usually be removed at the end of the lease. If items are brought onto the premises and are fixed, but they're not for tenants trade or business, then those will be landlords and fixtures, and usually must be left and become the landlord's part of the premises at the end of the lease. And then you can have this other concept of not being fixtures at all and being part and parcel of the premises. So it is a matter of looking at exactly what the lease says. The one question that I haven't been able to get to the bottom of on this case is why is there a whole court case about the replacement of 2 front doors? But I can only assume that it was because of a precedent would be set, and it was important to keep the whole block looking smart and consistent. But I don't know. Well, as I always say, and you're always very welcome to give us a call on an informal basis, just to ask any quick queries or run something by us. We're very, very pleased to do that, and very pleased to hear from you. So I'm going to finish it there, but thank you very much indeed, everybody, for joining us today and for listening, and we do hope you found it useful. Have a good rest of the day. Thank you.